Thank you, everyone. Welcome to this talk. So just to set the record straight, this LLM here actually stands for Masters of Law. I'm a lawyer by training. I don't know if I'm the Master of Law, but in any case, I hold the title. I'm, besides being a lawyer, I'm also an interdisciplinary researcher at ICF. And because this is, today is a day for inspirational talks, I'd like to inspire you to stop thinking about data in proprietary terms, because there is hardly any intellectual property in data, and I'm going to show you why in a few moments. So first of all, I'd like to discuss where data stands in the framework of intellectual property law, and particularly copyright law, and to offer a perspective on how we should instead think about data when it comes to its legal governance, so to say. So the situation from an international copyright law perspective is fairly simple. This is Article 10 of the TRIPS agreement. So for those of you who don't know, and I assume most of you don't know, the TRIPS agreement is actually one of the few recent international intellectual property agreements which actually harmonizes the trade-related aspects of intellectual property. So that's what TRIPS stands for. And this is the only piece of internationally harmonized regulation which actually says something about the status of data. So first of all, Article 10 says that computer programs, whether in source or object code, are protected as literary works under the Berne Convention. So for the non-lawyers in the audience, this might sound weird. But we have created this legal fiction to sort of assume, subsume, to be more precise, computer programs under the title of literary works so that source code can get protection. Now, by extension, also object code gets protection. And this is a bit weird because object code, well, it's anything but human readable. Nevertheless, this fiction was created so that we can protect the whole of the unit. The computer program is a unit, so both source code and executable. Now, when it comes to data, you have the agreement saying basically that compilations of data or other material, whether in machine readable or any other form, which by reason of the selection or arrangement of their contents constitute intellectual creation. So this is the criterion. For data to obtain any form of protection in the copyright law, it must have some sort of creative expression. And in European Union law, we call this the author's own intellectual creation. So there must be some sense of some degree of originality, and there must be expressiveness of elements that is fixated on a tangible medium. So these are the three requirements. So such protection, however, does not extend to the data or the material itself. So what do we mean by this? If you put in the effort, if you put in the intellectual effort to compile a collection of data, think of an anthology of poems, for example, then you would have an independent copyright over the anthology, and each author would have independent copyrights over each of their poems in this anthology. So what the copyright that you get is over the effort that you put into compiling these poems, for example. And the same goes for data. You would not get protection over the data, you would get protection over the compilation of data, provided that it meets this requirement for being an intellectual creation. So it's a very stringent standard. There is no IP in the data as such. There is no IP in the extracted data. There is no IP in the collected data. There might be other rights, but definitely not IP. Based on this provision in the TRIPS agreement, in the European Union, we have created something called the sui generis, or generis to be more precise in Latin, the sui generis database right. So what is that right all about? It gives basically creators of databases a 15-year-long exclusive right over their database. And the criteria are fairly similar to the ones in Article 10 of the TRIPS agreement. So you need to have put in substantial investment. So what we protect here is investment in the collection or presentation of the data, again, not in the data. Now, this right exists, but case law of the Court of Justice in Luxembourg has, over the years, so this directive, this was adopted in 1996, so almost 20 years ago, actually more than 20. And we this right has been gradually narrowed down. So literally now, even though it exists, you would find very few organizations that actually enforce this right. So we have very few cases over this right. Most of them are actually by airline companies that felt threatened by content aggregators of flight information. So Ryanair, for example, was a defendant was actually a plaintiff in one of the cases. But even though it exists, we are all very skeptical as to what its practical utility is and whether it actually has any merit. There was even a debate within the Commission whether this whole database directive should be repealed. It was not repealed, but the Data Act, for example, has a specific provision which says that any collections of data collected under the Data Act, so machine-generated data, sensor data, and so on, that these do not basically merit protection under the database directive. So this gives you an idea of how strong really the views of the Commission towards this directive are. Like I said, it protects the investment in obtaining or presenting the data, and the raw data as such, because this is where most people are interested to have some sort of exclusivity in the raw data, in the original data collected or extracted from a resource. The reality is that we don't have any intellectual property rights in this data. You would at best be able to protect it as trade secret, but then you enter the territory of trade secrets, and this information that you have designated as a trade secret must meet certain legal conditions under the Trade Secrets Directive. So it's not that simple. And many of my colleagues many of my fellow lawyers actually say that trade secret protection is a very bad fit for all data. That you might claim it, but if you were to end up in a court of law and argue it, it might actually turn out that you have very thin protection or none at all. So, how should we think about data generated from original works? Because copyright law, as I said, is interested in original works, the author's own intellectual creations. Let's say we have a poem, and we apply a tokenizer to this poem and we generate a set of tokens. What happens? So we have the original work on one hand, and then we have a series of data generated on the other end using a tokenizer. So one way to think of works is obviously as works, and this is a purposive approach. What do I mean by this? You access work and you interact with the work when you use it to basically extract its original content, to learn something literally from it, or to appraise its aesthetic value. This is why we read poetry, this is why we read books, this is why we go to exhibitions, installations, and so on, to consume art. Another possible view that has emerged with the development of the data economy is to see works as data. And this is something new, relatively new, at least in terms of copyright law, because with the amendment to with the new Copyright Directive of 2019, rights holders have to accept certain limitations to their exclusive rights under copyright law. And these limitations are broadly referred to as text and data mining. So what is text and data mining? It's basically any form of extracting patterns, correlations between data from original copyright protected works. And what the directive gives any third party, any commercial or non-commercial actor, is basically the ability to do this with original works of protected by copyright without having the permission of the author. So in essence, you would be able, provided you meet certain conditions on lawful access, you would be able to take a collection of original works and just literally extract the useful information from them. So in terms of patterns, in terms of relationships, in terms of correlations between different elements in the works. And you can do that without having to seek permission from the author. So works as data is another way of looking at works. And then finally, data is a work, so whether data can fit into the framework of copyright law, my personal opinion, and I think also the criteria set by copyright law, at least in a European context, meaning the author's own intellectual creation, I don't think how we could apply this ever to data. Now, something that I'd like to mention here is that the way we understand originality and infringement in copyright law, because you would hear from many people, especially in the creative industries, that their art has basically been robbed by big tech corporations. And I can see the reasoning behind it, and I can understand the ethical considerations behind such statements. But the reality is that in copyright law, we measure originality through the test of infringement. So, what is the test of infringement? To have an infringement, you would basically need to have substantial similarity on the one hand, and copying, which is presumed if you have lawful access to the works, or even unlawful. If you have had access to the work and there is substantial similarity between something you have created and the original work, then you are already in the territory of the infringement test. Now, some of my colleagues have proposed sort of a, we call it purposive reading of the word copying, and I actually subscribe to that view. And this is the fact that for infringement to occur, you must use the work as a work, meaning you must actually be consuming it to appreciate its aesthetic values. For example, if it's a piece of art or if it's a poem. Whereas in the case of text and data mining, you are not actually using the work as a work. You're using the work as a data, which means that you are not in the domain of infringement. You are not performing infringement because the use is different. Now, this view has not necessarily been confirmed by a court of law, but we have similar infringement tests in trademark law, even though it's a bit of an old one. In the old regime before 2015, there was a test in copyright law which required the use of a sign as a trademark. So unless you use a sign to, brand your own products or services, you would not be found in infringement even if you used that sign. Now, there is also the fact that in copyright, the use of the use as a work serves as a nexus of communication between the author and the public. This is really how the original work of art, for example, gets to its public. So this nexus is required for an infringement. In the case of data, you don't really have that. And we have general understanding in copyright law that the infringement provisions don't apply to technical uses. And now in copyright law, we have a specific provision for temporary copies, for example. So the caching that your browser does every time you load a web page, this is explicitly excluded by means of law. So it's non-infringing copy. And the reasoning is that using works as data, we could apply a similar approach to this. And because we are talking about sound in urban environment, there is actually a very interesting quotation I'd like to read for you from a recent case of the Court of Justice of the European Union, where they seem to subscribe to this view. So what we say in the course of Pelham was that so long as there is no reproduction, so that there is no reproduction so long as something is unrecognizable to the ear. And I'll read the full excerpt for you. So the court said, the aim of sampling, we're talking about sampling in this case of a phonogram, the aim of sampling is not to enter into dialogue with, be used for comparative purposes, or pay tribute to the works used. Sampling is the act of taking extracts from other phonograms which are used as raw materials to be included in new works to form integral and unrecognizable parts. Moreover, those extracts are often modified and mixed in such a way that all original integrity is lost. It is not therefore a form of interaction, but rather a form of appropriation. The case in point where an extract from a phonogram, too short to allow any interaction, is repeated in a loop throughout the new phonogram for use as the rhythm section is a perfect illustration. So in other words, sampling, taking little bits and pieces from an original phonogram would not constitute infringement because there is no interaction with the work as such. You are basically using the work as data. And you might ask whether the same goes for code. Many developers are increasingly using Copilot or other code generation tools, which come quite in handy. Yes, indeed. And you would say, well, code is a bit different because it is highly functional. Does it even belong in the system of copyright law? Many people ask, especially when it comes to the protection extended over the object code. Yeah, we could argue about this all day long. But the reality is that I don't see why it would not apply to code just the same. This is a visual that I made a long time ago for other purposes. Basically, there was a discussion as to whether if you have open source input, you would also need to apply the same open source license to the output. And my answer is no. Do you want to know why? Because I think that the instant you basically tokenize the training data, the instant you start interacting with the training data based on either a license or a statutory limitation like the text and data mining that we have, you lose, you break this, you sever this relationship between the original work and the generated data. Unless you can provably verify that you can go from the tokenized sequence to the original matter, to the original content, reproducibly. Meaning that you have a one-to-one relationship between the tokenized sequence and the origin and the training data, which is there is some research which has tried to prove sort of that this is possible, but for most people in industry, this is an excuse enough. Let me put it that way, to claim that the relationship between the training data and the learned model is severed, that there is no originality that extends across the value chain, which means that you could have training data under any open source license, if you wish, if we're talking about code, and you could have any sort of license applied to your generated code. Because we are talking about technical interactions and not using works as works. So, if we accept that there is no any form of intellectual property in data, what can we do? And why do I think it's actually not even helpful to think of data in ownership terms? First of all, because owning the data does not always mean you can use it. It's not just potentially intellectual property rights that would apply. You would have to deal with data protection concerns. You would have to deal with data localization concerns. Some data can't be exported across borders. You would have to deal with regulatory concerns, for example, in the health data, where you would also have to deal with ethics review process and so on and so forth. Additionally, I don't think that having the data necessarily always guarantees transparency. We have experience with open source software and source code availability. If that were the case, if Linus Torvalds is saying that given enough eyeballs, all bugs are shallow, then Heartbleed would have never happened. Yet Heartbleed happened. Heartbleed happened not because there was no source code. Heartbleed happened because there was an underfunded project hinging on one person's efforts, who was simply the maintenance of which was simply not tenable anymore. Yet the source code was available, the bug was there for years, and it was not detected. So we had the data, but it was not enough. Additionally, there is a great deal of debate currently ongoing on how we should define open source AI and whether the data information requirements is sufficient. So I'm actually proud to say that in the current definition of the open source AI, as a definition stewarded by the Open Source Initiative, there is not a requirement to provide the original data sets, but rather a requirement to provide data information, which means information about how the model was trained, but not necessarily, and not in any case, the original data sets. And this definition was largely inspired by a contribution that I made together with a colleague of mine from VTT during the debate on the open source definition last year at the OSI. And I think that's the right approach, because I don't think that requiring disclosure of data sets in every instance of any model that may be claimed as open source AI would make sense. And it would actually be impossible to comply with this sometimes because of other considerations. So instead of reasoning in proprietary terms, I suggest that we reason in terms of accuracy and timeliness, because this is what matters. This is what really matters when it comes to data. What tools, what legal tools do we have? Obviously, contract law. Go to any organization and ask them, how do you deal with data transactions? They simply execute contracts. That's how they deal with it. Yes, we now have new legal instruments like the Data Act, but what the Data Act does is it says you should be fair in your contractual terms, business-to-business contractual terms, meaning you can't just have any conditions. You need to comply with certain regulatory requirements that come from the law. But other than that, you have contractual freedom. You could do whatever you wish. And we have hints already in the legislation that, for example, in the GDPR, there is a requirement controllers must ensure that personal data is always accurate. In the AI Act, providers have an obligation to ensure level of accuracy and relevant accuracy metrics of high-risk AI system. They must be declared in the instructions of use of an AI system. And the legal criteria for timeliness, we don't necessarily have them. So, for instance, in the GDPR, we have a simple hint that data must always be kept up to date, but no actual requirements as to how this should be done. And to me, this should be done by means, again, of contract. We should go back to the drawing board of the service level agreements that we sign with cloud computing companies, with the contracts that we execute with other business partners, and actually define accuracy and timeliness in a business and legal sense, so that it actually has any meaning. So before, this is my last slide, I think that we really need to build data strategies oriented towards accuracy and timeliness, and this is paramount, and we should definitely do it before we start developing AI strategies, because today everybody jumped on on implementing rudimentary risk management systems for AI. I think that before we do that, we really need to nail down the data strategy, which is still a tough nut for many organizations. Thank you very much.